Hello students, how are you? Today's topic is on Article 15 of the Constitution of India, which says prohibition of discrimination on the grounds of religion, race, caste, sex and place of birth. Total 5 grounds on which the state cannot discriminate among the citizens of India. Article 15 is applied only to the citizens of India. Article 15 does not apply to non-citizens or the foreigners. Is very important. Clause 1 of Article 15 says the state shall not discriminate amongst the citizens of India only on the grounds of religion, race, caste, sex and place of birth. Total 5 grounds. So it means state can discriminate among the citizens on other grounds besides these grounds which I have already told you. That is, the state can discriminate among the citizens on the basis of residence or descent or place of birth. This I will be telling you afterwards in a case law, because residence or domicile is different from place of birth. Clause 2 of Article 15 says no citizen on the above grounds is subject to any disability or restriction with regard to access to shops, public restaurants, hotels, places of public entertainment like cinema, theatres, or use of wells, tanks, bathing ghats, roads and places of public resort like public gardens, maintained wholly or partly out of state funds or for general public purpose. So, in clause 2, it is said that nobody, neither the state nor the private individual, can discriminate amongst the citizens of India just if the citizen of India is going to any shop. He cannot be discriminated, that he cannot be entered. He is not allowed to enter in that shop because he belongs to certain race or caste or sex. Everybody is allowed to enter any shop in the market. Everybody has right to access to shops, public restaurants, hotels, public places of public entertainment. And even in villages we see there are many wells and tanks. So that well or tank, everybody has the right to use that well or tank or bathing ghats or roads. Roads are for everybody. No private individual or even the state can discriminate among the citizens while using the roads. Roads are for public purpose, and even for big malls and theatres and markets. These things are for public. Every citizen can use these things. He can go to roads, he can use the roads, he can use the ways and highways. He can go to any shop. Nobody can discriminate among a citizen that he belongs to a particular caste or particular group and he is not allowed to enter the shop. If anybody is doing this, he will be liable under the penal law and SC/ST Act also. So, Clause 2 prohibits discrimination both by state and private individuals, while Clause 1 prohibits discrimination only by the state. It's very important. Now Clause 3, this is the first exception to Article 15. Clause 3 says that the state can make special provisions for women and children. For example, reservation of seats for women in local bodies and panchayats. Already 33% reservation is there for women in panchayats and local bodies. Though in parliament up till now, women have not got 33% reservation. And for children, there is free education, right to free education. Clause 4 is the second exception to Article 15. Clause 4 says special provisions or special general provisions can be made for the advancement of any socially and educationally backward classes of citizens, that is OBCs, and for SCs, scheduled castes and scheduled tribes. So state can, under clause 4 of Article 15, can make special provisions for the socially and educationally backward classes of citizens, that is OBCs, and the scheduled castes and scheduled tribes for their advancement. This is the second exception to Article 15. Third exception is given in Article 15 clause 5. Third exception says the state can make special provisions for these OBCs, other backward classes, and SCs and STs with regard to admission to educational institutions. So the children of SCs, STs and OBCs, they can be benefited through this clause 5. Clause 4 was giving general provision for the advancement of socially and educationally backward classes and SC and ST. But clause 5 is specially for admission to educational institutions. So the children of these SCs and STs and OBCs, they can get benefit under clause 5 and they can get admitted to the educational institutions. A certain quota is reserved for their admission. Whether that educational institution is aided or unaided by the state, it doesn't matter. But exception here is minority educational institutions like schools established by minorities like Sikhs and Christian missionaries. Under this thing, this minority educational institution, these minority educational institutions are not covered under exception 3 of clause 5. It means minority educational institutions need not to reserve seats for OBCs or SCs and STs. Clause 6, very important. Clause 6 was added by the 103rd Amendment Act 2019 by Modi government. So by 103rd Amendment Act by 2019 by Modi government, special provision can also be made for advancement of any economically weaker sections of citizens other than the above given backward classes like OBCs and STs and STs. So here comes the general category also. Now general category can also be benefited by the reservation procedure. Clause 6 is made specially for the general category by the Modi government. What do you mean by any other? Any other means those who are not SCs or STs and OBCs. It means those who are in the upper caste quota, those who are in the general category, they can also get benefit of reservation. So up till this 103rd Amendment Act 2019, when it was not passed, the present situation was that reservation was given only on the basis of socially and educationally backwardness. Only social and educational backwardness was the criteria for giving reservation to OBCs and SCs and STs, as held by Supreme Court in the Mandal case or Indira Shani case in 1992. Indira Shani versus Union of India 1992. But now from this amendment of 2019 by Modi government onwards, reservation can be given even on the basis of economic backwardness, which although earlier held by Supreme Court in Mandal case that economic criteria cannot be the sole basis of reservation. So from now onwards, that is from the implementation of this 103rd Amendment Act 2019 by the Modi government, even the persons belonging to general category are eligible to reservation. Actually what happened, I'll tell you the story. Actually what happened was that on 7 January 2019, Union Council of Ministers had approved 10% reservation in government jobs and educational institutions for the economically weaker sections in the general category. It was decided by the cabinet that this would be over and above the existing 50% reservation limit fixed by Supreme Court in Indira Shani case 1992 or Mandal case 1992. So Supreme Court had fixed the reservation to 50% in Mandal Commission case. Reservation cannot be more than 50%. Supreme Court had said this in this Mandal case 1992. This judgment is very important. But by 103rd Constitutional Amendment Act 2019, Modi government has increased this 50% to 60%. Now this reservation of 10% given to the general category candidates is also called, which is also called upper caste reservation. This 103rd Constitutional Amendment Act actually was passed in 14th January 2019. It came into force on it was actually initiated on this 7 January 2019, but it was implemented. This 103rd Constitutional Amendment Act 2019 was implemented on 14th January 2019. So present situation now is the total reservation can be 50% earlier limit as fixed by Supreme Court in Mandal case plus 10% reservation of the general category, total becomes 60%. 50% reservation in the Mandal case as held by Supreme Court in Mandal case in 1992, this case was decided, plus 10% reservation by 103rd Constitutional Amendment by Modi government. So total reservation becomes 60%. Now up to 60% reservation can be there. Up till 60% reservation, out of 100%, 60% seats can be reserved. This 10% reservation is given to the general category by the Modi government. 103rd constitutional amendment, very important for your judiciary preliminary exams. Now total reservation is 60%. This new quota, this new quota, 10% quota, targets the poor among the general category. This 10% is of general category. This is the poor, economically poor. This 10% is the economically poor from the general category. So they are being benefited by this 10% reservation given by Modi government. This new quota of 10% targets the poor among the upper caste general category, that is who are economically weak. Now who are these persons who are getting benefit? These are those who are having annual income, annual household, very important, annual household income below 8 lakhs. Below 8 lakhs. Households having annual income below 8 lakhs, they are benefited. Or those having agricultural land below 5 acres. Next, those having residential house below 10 square feet. Next, those candidates of general category having residential plot below 100 yards in a notified municipality. Next, those candidates of general category having residential plot below 200 yards in non-notified municipality area. So these are the persons who can get benefit through this 10% reservation. Every household, I have told you, those having annual income, every household income below 8 lakh. Now what do you mean by every household? Household has been defined like this, very important. Household. This household means is included, very important, just listen, person. Which person? Which person who applies for the reservation? He can be male or female. Person plus his or her parents, plus her partner, partner can be wife or husband, plus her siblings, less than 18 years, plus his children, his or her children, less than 18 years. So these are the persons who are included in the household who can get benefit of 10% reservation among the upper castes or general category. Is it clear? Now total income of 8 lakh includes income derived from salary. This 8 lakh includes income derived from salary plus agriculture income plus business, any business if he is having, plus profession, any profession. So total income of all these, salary if he is getting a salary from private or he is a government employee, plus agriculture income plus business plus profession. So it becomes total is minimum 8 lakh. If he has minimum 8 lakh annual income, then he can be eligible for reservation. Below 8 lakh, not above 8 lakh, below 8 lakh. The maximum limit, not minimum, I'm sorry. Maximum limit is 8 lakh, not more than 8 lakh. If a person gets through all these sources maximum 8 lakh, he can be eligible for reservation. Now up till now, since the passage of judgment in Indira Sahni case in 1992 or Mandal case, the reservation quota was like this. Up till now, before the passing of this 103rd Constitutional Amendment Act 2019 by the Narendra Modi government, up till now, Mandal Commission case was implementing in the case in this India. Mandal Commission, according to Mandal Commission case or Indira Sahni case 1992, reservation was like this up till now, which is changed now. 7% reservation was given for SC. 15% reservation was given for STs, and 27% reservation was given for OBCs. Here in OBCs, creamy layer was excluded. So 7% for SCs, scheduled caste, 15% for scheduled castes, scheduled tribes, and 27% for OBCs, other backward classes. And in other backward classes, creamy layer was excluded. Creamy layer were barred from reserving from this reservation benefits. Now, what do you mean by creamy layer? Creamy layer among OBCs are the persons who are in the, for example, if he is in the post of the president, a person of OBC, if he becomes a president or was vice president of India, or he is in a group A or class 1 officer's job, or he is in group B class 2 officer's job, or he is in IAS, IPS, he is in all India services, he is in a central services, state services, gazetted officer, persons who are in the rank of colonel in army, navy, air force, professionals like doctors, lawyers, engineers, persons having gross annual income of less than 6 lakhs. Less than 6 lakhs as updated in 2013. So these persons were included in creamy layer in OBCs. So creamy layer were barred by the Mandal Commission case, and they were not eligible for reservation. Now, Supreme Court in Mandal Commission case or Indira Shani case, as is one and the same thing, in 1992 held that the separate reservation for economically poor among the forward class is invalid, as Article 15 Clause 4 provided reservation only for socially and educationally backward class. So, under Mandal Commission case, the Supreme Court held that the reservation among the economically forward class is unconstitutional, or it is void. It's not proper, it's invalid, as Article 15 Clause 4 says only about socially and educationally backward class, not about economically backward class. Now, 9 judge bench in this Indira Kashani or Mandal case held that a backward class cannot be determined only and exclusively with reference to economic criteria. Economic criteria is not the sole basis of giving reservation, which Modi government has made it a criteria. Now at present, Modi government by 103rd constitutional amendment had made economic criteria also the basis of reservation. But up till now, economic criteria was not the basis of reservation. So 9 judge bench in Indira Sani case or Mandal Commission case held that a backward class cannot be determined only and exclusively with reference to economic criteria. It is the social backwardness, very important. It is the social backwardness and educational backwardness which should be taken into consideration before giving reservation. But now, after 103rd Constitutional Amendment Act 2019 by the Modi government, reservation of 10% is also given to economically backward class citizens among the upper caste, that is general category, under clause 6A of the Article 15. Under clause 6B of Article 15, reservation to these 10% general category people, 10% economically poor general category people is also given to them with regard to admission to educational institutions like schools and colleges. So children of economically backward class who comes in this 10% category, the children of these general category candidates can be given a reservation in the schools and colleges, whether it's private educational institution, private college, or government school, it doesn't matter. But or whether it's aided by the government or not, it also doesn't matter. But it should not be minority educational institution, for example, a Sikh institution or a Christian institution. So this was the main background of reservation given by Modi government to this economically poor among the general category. Now, very important for your judiciary exams, Article 15 case laws with regard to Article 15, very important, note it down. The first is, just a minute, the first case is very important. First case is this Saurabh Chaudhary versus Union of India, AIR 2004 Supreme Court. Saurabh Chaudhary versus Union of India, AIR 2004. In this case, it was held that the place of birth is not domicile. Article 15 covers only place of birth. However, Article 16 covers place of birth plus residence and domicile also. place of birth is not synonymous to the expression domicile, as place of birth and domicile reflect two different categories, two different concepts. Place of birth is different. A person can have a different place of birth, but he can have a different domicile. Domicile is the place where he is having a house and he is living there. He is having a residence. But he may not be having a residence on his place of birth. He may be having a different place of birth. But his residence or domicile may be different. So this was held in this Saurabh Chaudhary versus Union of India. So under Article 15, reservation in educational institutions in a particular state, whether it's Haryana or Punjab, for candidates on the basis of the domicile certificate or residence certificate can be allowed. So every state can allow reservation for their own state candidates who are having domicile of their state. So this can be done by a particular state. Now next case law is very important. Faculty, FACULTY, Faculty Association aims, Faculty Association aims versus Union of India, 2017 AIR. This is very important for Article 15. Case law for Article 15 is Faculty Association. This is second case, case 2. Faculty Association aims versus Union of India 2007. In this case it was held, please note it down, the rule of reservation is not applicable for specialty and super specialty faculty posts in the medical area. I again repeat, the rule of reservation is not applicable for specialty and super specialty faculty posts in medicine. The next case is third case, case 3. Case 3 is for the Article 15 is Meera Kanvaria versus Sunita, AIR 2006, Supreme Court. Case 3 of Article 15, Meera Kanvaria versus Sunita, AIR 2006, Supreme Court. In this case it was held, please note it down, a person by reason of marriage, a person only by the reason of marriage alone cannot ipso facto, a person by reason of marriage alone cannot ipso facto become a member of scheduled caste or scheduled tribe, and so cannot take the benefit of reservation. So if a person is marrying a general category candidate, for example a person of general category, he marries if a female is of a general category and she marries a male of scheduled caste category, ipso facto doesn't mean that after marriage she will also become a scheduled caste. She will remain a general category candidate. So just by marrying a person of a scheduled caste or scheduled tribe, you cannot get his caste, or you cannot become a scheduled caste. You cannot leave your caste. Second, other important case is case 4. Case 4 is very important for your judiciary exams. Case 4 for Article 15. Case 4 is Kailas versus State of Maharashtra, AIR 2011, Supreme Court. Kailas versus State of Maharashtra, AIR 2007, Supreme Court. 2011, sorry. Kailas versus State of Maharashtra, AIR 2011, Supreme Court. In this case it was held, noted down, the historically disadvantaged groups would be given special protection under Article 15 so that they can be uplifted from their poverty and low status. This was the fourth case. Then the fifth case, case 5 for Article 15 as far as judiciary is concerned is Rajesh Kumar Gupta versus State of UP, AIR 2005, Supreme Court. This is your fifth case for Article 15. Rajesh Kumar Gupta versus State of UP, AIR 2005. It was held in this case by Supreme Court that reservation of 50% posts in favor of female candidates not arbitrary. If a particular state government reserves certain posts for the female candidates only, it is not arbitrary and it is valid and constitutional as per Article 15. Then the next case for Article 15 is very important for the judiciary exams is case 6. This case is Dattaraya versus State of Bombay. I'm sorry, my writing is a little bit bad, but you can easily, I think, see this. Dattaraya versus State of Bombay, year 1953. Dattaraya versus State of Bombay, year 1953. In this case, it was held that the provisions providing for reservation of seats for women in local bodies like panchayats and municipalities. So, provisions providing for reservation of seats for women in local bodies or in educational institutions are totally valid and they are constitutional as per Article 15. I have already told you in Article 15 Clause 3, special provisions can be made for the benefit of this woman and children, and this is the first exception to Article 15. These exceptions are given in Article 15 itself. Article 15 Clause 1 and Clause 2 says that state cannot discriminate against any person, any citizen, just on the basis of 5 grounds: sex, place of birth, caste, religion, etc. But in Clause 3, 4, 5, special exceptions are also given by the Article 15. Then the last case is Case 7. Case 7 for your Article 15, Prohibition of Discrimination, for your judiciary exams is very important. Is Visakha, very important case. Very important case. Visakha, landmark case. Visakha judgment, landmark case. Visakha versus State of Rajasthan, AIR 1997. Visakha versus State of Rajasthan, AIR 1997. You should read this judgment. You can go, you can search Google. You should read this judgment. Very important judgment as far as rights of the woman are concerned in India, in a country like India. So up till that point, up till this judgment, basically only penal law was there. For example, rape, 376, and all these were given in IPC. But special protection for them in their workplaces. There was no actually no guidelines. There were no circulars, and there was no code or codified law. So up till the codified law is made, the Supreme Court in Visakha versus State of Rajasthan had made it clear, very important, that sexual harassment of women, working women, sexual harassment of working, please note it down, sexual harassment of working women amounts to violation of their rights granted by Article 14 and 15 of the Constitution, and hence special protections should be made by the state governments for their safety in their workplaces. So this was very important judgment. So these all 7 cases were for your Article 15, Prohibition of Discrimination on the grounds of 5 grounds. What are the grounds? I'll be again repeating them for you. The 5 grounds are: the state cannot discriminate on the basis of religion, race, caste, sex, and place of birth. Total 5 grounds. In Article 16, there are total 7 grounds. So in Article 16, residence and descent is added. But in Article 15, there are only 5 grounds. But in Article 16, which we will be dealing with in the next video, there are 7 grounds. Article 16 basically is for the employment in government jobs. The state cannot discriminate between the citizens for getting employment in government jobs on the basis of these grounds. 2 more grounds are added in these and in Article 16. So this was your Article 15. I hope you have liked the lecture. In the next lecture, we will be dealing with Article 16, 17 and 18. Thank you very much. Sat Sri Akal.